Okay, it's Wednesday. This is Life in the Law from 1 to 2 p.m. and we're talking about the state of the judiciary in 2015. And we have three guests. We are honored to have these three guests. Chief Justice Mark Recktenwald is here right now. Welcome to the show, Justice.
Thanks for having us, Jay. Really appreciate it.
Great to have you here. It's an honor to have you here. Judge Mark Browning in the Family Court, the First Circuit Court, Family Court. Thank you very much for being here, Judge.
It's great to be here. Thank you.
And we have Judge Steven Alm, also in the First Circuit Court in the Criminal Division, and he's the creator of the HOPE Project, which we will discuss today.
Hi, Jay.
Thanks for coming down. So just to say that in January of every year, Justice, you do a report to the legislature. You come down and you talk to the House and the Senate all together, and you report on the status of the judiciary, and you did that this year on January 28th, and it reflected a lot of programs and innovations that we haven't heard about before, so it's really exciting to have you here to discuss them. The four things that you talked about in those remarks are access to justice, enhancing public safety, protecting Hawaii's children and families, and preparing for the future with all kinds of other new ideas. Very exciting to read the speech, very exciting to see the notes of it. This is where, in my one comment I want to make, the rubber meets the road. The public out there isn't necessarily connected with government. Lord knows, only 40% of our citizens vote, who could vote. With respect to the courts, it's involuntarily. Sometimes they have to be involved. They have to have contact. And these programs that you talk about, these courts are where the public meets the government for sure. And that's why these programs are so important. So, Judge, can you give us a handle on how it went? Can you embellish a little on exactly what you covered in the state of judiciary?
Yeah, absolutely, Jay. It's actually every other year is the tradition. It's a report both to the legislature and to the public as a whole about where we're doing the challenges we see, what we're doing the challenges we see, and the programs we have to meet those challenges. And really, our mission at the judiciary is to deliver justice for all, and that's what I talked about in my remarks. And what I've learned as Chief Justice is we do that in many different ways. We do it by adjudicating cases. I mean, that's the key core part of our mission that I think everyone is familiar with just from watching television or being part of the community. They understand we decide cases. But over time, we've taken on other responsibilities as well. And really, we've been asked to address some of the root causes that bring those cases before the court. So whether it's a defendant who's addicted to drugs and that's what's brought them into the system, victims of domestic violence, children whose families are going through the trauma of divorce. The underlying issues are things that we need to get at and also be able to ameliorate the effects, for example, on those kids whose parents are going through divorce, or in the instances of folks who have been addicted to drugs, and that's bringing them into the criminal justice system. Find ways to be able to get them clean and sober so that we reach the ultimate goal of not having them come back before the courts again in the future and keeping their communities safe. So it was very exciting for me to have an opportunity to talk about some of the things we're doing, whether it's access to justice, which is ensuring that everyone's voice is heard when they come before our courts, and especially in our civil cases, to being sure that when we look at our criminal justice system, we're getting the results we want for the resources that we have, and looking at what we're doing in family court and all of the people who are affected there so profoundly. How are we meeting those needs? And then generally to look at where we're headed for the future. So it's really an exciting opportunity for me to be able to share all that with the legislature and the public. And I really appreciate the Senate and the House for letting me come before them this year and deliver those remarks.
Well, sounds great. Judges and the judiciary in general, they interface with the community. They have the data, so to speak, of what happens in these cases. These cases are not just cases, they're data to learn from. And it's great to see the judiciary learn from that and do social policy and actually try to, fix things in the community. This is a wonderful thing.
And I think you'll hear that today. That we're constantly looking at the results we're achieving. Are we getting the best possible outcome we have for the scarce resources that the community has to address these issues? And are there better ways, more effective ways that we can go about solving them? And that's something we constantly ask ourselves.
Well, in access to justice, there was reference in the speech to the Access Commission. Can you talk about that?
Yeah, so access to justice, and it refers in this context to civil cases. So when our citizens come before the court, whether they have a landlord-tenant dispute, it could be a divorce case, could be a conflict between neighbors, whatever it might be. There are literally thousands of citizens and, or members of our community who, when they come before the courts, they can't afford a lawyer. And so we're trying to meet that need. How is it that you can ensure that those folks either have somebody who can represent them, whether it's someone like the Legal Aid Society or another legal services provider, or if they have to represent themselves, that they're able to do it in an effective manner. And you know, the court system can be, it's not always intuitive. What's required, where you go, what kind of document you have to file, what the judge needs to hear, or what's important in the case isn't always intuitive. So for those people who have to represent themselves, the key is to find them, get them some help and some ability to understand how to do that effectively. And the best mechanism, or the mechanism that's really brought all of our resources together, was the creation of an Access to Justice Commission. That was back in 2008. There's 20 members, judges, community members, legal services providers, members of the legislature, all coming together to focus on this one issue. How can we increase the services that we provide to folks who come before our civil courts, and to ensure that they're able to tell their side of the story so their voices can be heard.
And so the commission tries to find ways to do that.
Absolutely, and it's, you know, the first chair was Justice Simeon Akoba, my colleague. Now it's ICA Judge Dan Foley from the Intermediate Court of Appeals. And they've really focused on a lot of different things, providing increased support for our legal services providers like legal aid, providing incentives to attorneys to volunteer their time, what we call pro bono, to volunteer their time to help, and then providing mechanisms or opportunities for them to do that. And the biggest one has been opening self-help centers in our courtrooms. So at these self-help centers, the attorneys come and they volunteer their time to be able to provide information or limited advice to individuals who are representing themselves in our civil cases. They can help them understand what forms are needed, understand what might be relevant in their case, and be able to tell their side of the story. We opened the first one of these on Kauai in 2011. We now have 6 of them across the state. Again, they're staffed by volunteers, and we've helped almost 8,000 people at these centers, really at almost no cost to the public since 2011. It's been a great step forward. It's something we're very proud of, Jay, and very thankful to the attorneys who help and our other partners, the Legal Aid Society of Hawaii, the William S. Richardson School of Law, and many others who've come together to enable us to do this. And the Hawaii State Bar Association has been great.
It's great to see them all come together. The other aspect is, in the past, this wasn't really happening. In the past, this wasn't available. I mean, the Legal Aid Societies existed for many years, but it was really the only choice for a lot of people.
Well, there was something called Volunteer Legal Services Hawaii, which still exists, and it's a great mechanism too. But I think what we learned is the attorneys really wanted to help. The attorneys, I think, understand that they have an obligation to give back to the community, but you have to find a way in which they can do that they're comfortable with, and that makes it, in essence, makes it easy for them to be able to donate that time. You know, attorneys are worried they're going to be practicing in an area that's not their area of expertise. So how do you have somebody who does civil litigation all day help somebody with landlord-tenant cases? The answer is you have training, and we've developed that training and made it very effective and very efficient so that the attorneys can get trained. We have the centers set up and operated for them. And we've addressed some of the ethical concerns or concerns about conflicts of interest. We were able to address those through rules that provide clear guidelines about what they can do and when they can do it. And all of those things came together to make this opportunity available to attorneys, and they've really responded to it in a way that is just, to me, is tremendously impressive.
It's payback, that's what it is. So what is the software now, A2J? I guess that means access to justice. How does that work?
So, you know, the centers are brick and mortar. So they're in 6 of our courthouses, but they're going to be people who can't physically come to the centers. And there are going to be times when you're going to have folks who, even if they can come to the centers, they might be able to come briefly and get some information, but not be able to do everything related to their case during the time they're there. So we knew we needed to reach out into the community and make it easier to get this kind of assistance. And so what we did is, working with the Legal Aid Society of Hawaii and the Legal Services Corporation nationally, developed software that basically asks questions, has a conversation with the person who's going to be going to court, asks them about their case, about the issues, and basically through that interaction is able to fill out the forms that they need to file in their case, to present their side of the story. And we've done that now. I think there are about 12 or 13 of the most common forms in the first wave. We're doing another wave of forms to make more services available. But the idea then is that somebody can go online and be able to answer this, interact with this program, and be able to generate a form that is suitable for and will be effective when they file it in court. And that's available now on our website. It's on the Legal Aid Society of Hawaii's website. And it's been just a great step forward. It makes it that much more accessible to people who are trying to represent themselves.
Sure. And it's perfect that you do it, and it's perfect that there's already software concepts out there that you can use.
That's right. And so it's not unlike TurboTax. I guess that would be a rough
Turbo law.
Turbo law. Now, that's kind of the rough idea that you interact with the program and you tell it what your situation is. And the thing that we've tried to do, the other step we've tried to take, Jay, is realizing that even being online, there's folks who you're not going to reach as much of the community as you want to reach. So the partnership we developed that we're really excited about is with our public library system. So we're working with the Hawaii State Public Library System. We've rolled this program out now in our state libraries. So it's available on, I think it's about 1,000 computers at our state libraries across the state. We've trained librarians about the program and how it can be used. There's programs or events that are being held in some of the libraries to make the community aware of it. And so it's that much more outreach into the community and reaching that many more people. And we're very, very excited about that and thankful to the library. It's a great partnership. Librarians are passionate about sharing information. We have a lot of information to share.
So are you getting feedback from the public on this? You have public acceptance, public appreciation?
It's amazing when you read the comments from the self-help centers. They're very, very moving. People are incredibly appreciative of the help they get, and often it's just that there's somebody who's willing to listen to them and provide some context or some perspective for the issue that they face. But the response from the folks who come into the center is overwhelmingly positive. The response from the lawyers, overwhelmingly positive, and we're really making a mark, I think, in Hawaii by doing something that really is causing people to sit up and take notice. There was a survey done nationally of all the access to justice efforts across the nation. We were rated in the top 5 for all of our efforts, and in particular for helping folks who are trying to represent themselves. We were rated up at the very top. So, we're doing stuff that's really causing people elsewhere in the country to take notice. We're very, very proud of it. And again, it all starts with the lawyers who are willing to volunteer their time, both from the Hawaii State Bar Association and then the county bar associations on the neighbor islands.
And it starts from you as the administrator of the judiciary.
Well, I think it's really a grassroots effort, and it's amazing how much people wanted to help, and I think it was just a question of providing them the opportunity to be able to do that in a way that's effective and maximizes the benefit of their time.
Well, Judge, speaking of opportunity, I'd like to take this moment and give your colleagues here at the ThinkTech bench an opportunity to concur or dissent as they may wish. Judge Browning?
I concur.
Knew you'd say that. Want to add anything?
The vision that the Chief Justice has outlined is something that we've carried throughout everything that we do in family court. Our family court is unique in that we are a unified family court. And as such, we're a model for the nation. And by a unified family court, what I mean specifically is that every issue, whether it be criminal or civil involving children or families, comes under one roof. So it's really important to have a broad vision that encompasses access to justice issues and all the things that the Chief Justice outlined in the State of Judiciary's address.
It's a new time, I think. Judge Alm, how about you?
Well, I concur with everything that was said, but what I really appreciate is the willingness to allow innovation, to do things a new way, because as judges in the criminal justice system, we're kind of uniquely positioned. We can call a meeting, everybody comes. And people on the outside would not be able to do that. We can do it, we know the systems, but it's working together. It's getting everybody involved in a problem, working together to try to solve, as was described, some of society's most intractable problems. And so I'm really excited about that. I'm excited about what's happening at courtrooms around the state at the different levels, at the circuit court, at district court, family court, at all of the levels. So I think it's an exciting place to be.
it's perfect for the judiciary to do that too, to address these social issues and correct them in the field. It's easier for you, you're closer to it than the legislature, or for that matter, the executive branch, and it's great that you're doing it.
And I think we're trusted by the public. When we all do jury trials, people at first are like, oh, you know, this is going to be a hassle or whatever. But almost nobody, once they go through the process of being a juror, complains at the other end of it. They realize it was their part to do it. They're being a citizen like everybody else. They would want other people being inconvenienced if they were charged with a crime. And so we all, you know, enjoy that experience of doing jury trials. As, you know, as was said, our day job is hearing cases, adjudication. But it should be more than that. And we're all in situations where we can do more than that by doing all of these other special projects.
That's great. Let's take a short break. That's Justice Mark Recktenwald, Chief Justice of the Hawaii Supreme Court, Judge Mark Browning of the Family Court First Circuit, and Judge Steve Alm of the First Circuit, and in the Criminal Division. This is Life in the Law. We're talking about the state of the judiciary in 2015, every 2 years.
Every 2 years.
Next time we'll do it 2017. We'll be right back after this short break.
Aloha, I'm Kili'i Akina, president of the Grassroots Institute and host on Ehana Kako, a weekly program on the ThinkTech Hawaii broadcast network. Ehana Kako means let's work together. Think of the sad alternative, let's not work together. Here in Hawaii, with all of our diversity and the richness of the people, it's important for us to come together around issues on the basis of what's right and what's good and what's going to serve the common good. And that's what we try to do at Ehana Kako. Every week we interview movers and shakers, people in government, business, and other sectors of society to talk about how to create together a better government, economy, a better world here in Hawaii that can bless the rest of the world. I thank you for your attention to ThinkTech Hawaii, and we look forward to seeing you every Monday, 2 to 3 p.m. on the ThinkTech Hawaii Broadcast Network. We're Ehana Kako, and we wish you well. Aloha.
Okay, we're back, we're live. We're here with 3 judges who you need to know. Justice Mark Recktenwald, the Chief Justice of the Hawaii Supreme Court, Judge Mark Browning of the Family Court, the First Circuit, and Judge Steven Alm in the Criminal Division of the First Circuit. We're talking about life in the law here on our Wednesday program 1 to 2. Today we're talking about the state of the judiciary, which was a speech that is made every 2 years to the legislature by the Chief Justice. So moving on to other points that were covered in your remarks to the legislature, Justice Recktenwald, can we turn to Judge Alm and talk about enhancing public safety? There are a lot of initiatives that are referred to in your speech, and let's cover some of them.
Okay, well, the judiciary for years has tried to bring special attention, special training to various groups. So drug courts started about 20 years ago here for folks with serious drug problems. More recently, there's been a mental health court. So you have one judge dealing with a lot of the mental health professionals and folks coming in. And more recently, veterans court started. And so for our veterans who are having problems on probation, we have a place to send them as well. But part of it is because at sentencing, probably 25% of defendants get sent to prison for multiple year sentences. But that means 75% are going to be in the community. And the problem in Hawaii and across the country is many people fail at probation and end up in prison. Prison in Hawaii costs $46,000 a year. So when I was put on this current calendar 10 years ago, I would see motions to revoke probation with 10, 15, 20 violations. And I realized nothing had changed since I'd been a deputy prosecutor 15 years before. But also I realized it wasn't the PO's fault. We've got caring, smart, dedicated probation officers. They're trying to work with the clients. It was the system itself that needed changing, because the probation officers had 2 choices. Some people are going to do well on probation. They're scared, they come into the system, it has a shocking effect, they're going to do well. But many are not. Substance abuse issues, mental health issues, and the like. And when they start having problems, the probation officers have 2 choices. Work with them, encourage them, refer them to treatment, or if they find them a danger to public safety, refer them back to court and ask me to give them the 5 or 10 years in prison. It's all or nothing. And I thought, that is no way to change people's behavior. And I really thought to myself, well, if this doesn't work, what would work? And I thought of how my wife and I raised our kid, how were we raised? Your parents tell you they care about you, they want you to be successful, but if you misbehave, your parents are going to do something immediately, and that's what we try to do with our kids. It doesn't have to be harsh or severe, but it's got to be swift and certain, proportionate, consistent. And then they tie together the bad behavior with a consequence. They run out on the street, boom, the parents are going to grab them, sit them down, they're going to, whatever they do as far as the sanction, it's got to be done right away. And I realized our probation system, through nobody's fault, was akin to a parent telling their kid when they did something really bad, oh, don't do that again, repeatedly, and then a year later disowning them and kicking them out of the house. And so I thought if we could bring good parenting to the judiciary, we might be able to help folks do better. So that was the simple idea, but getting everybody organized, working together. So for example, if somebody comes to the probation office, tests positive for drugs, alcohol is the biggest problem in the criminal justice system, but illegally 60% of the positive tests are for methamphetamine. If they test positive and admit to it, I wanted them arrested on the spot. Go to our cell block at the courthouse, go to the jail, we have a hearing 2 days later with the prosecutor and public defender. And I thought that could be a teachable moment.
And this doesn't require a statute. You can
No.
do this at the judiciary level.
Absolutely, because we already have statutes for motions to revoke probation, and we thought, let's do it as a modification rather than a revocation. And up until that point, modifications had been used to add a mental health condition, or a defense counsel would come in to say, oh my God, wants to go work in California for 90 days. Our modification was a short time in jail and back to see the PO, the shortest possible time to tie together a behavior with a consequence. And the reason this works, we're convinced, is the probationers think it's fair. They know they're on felony probation. They know there ought to be rules. Well, now the rules are laid out clearly. You test positive and admit, it's 2 days in jail. You test positive and deny it, and the lab confirms that it's 15. You run away and law enforcement looks for you, it's 30. And in fact, if you show up late and you test clean that day or the next morning, we don't even arrest you. We'll set the hearing for the next day off or another time, and we'll lock them up in the cell block at the courthouse for a few hours. But because I only see them when they violate, unlike drug court where you have review hearings and you see them constant, when I only see them when they violate, it allows me to supervise 1,900 felons at the moment on this program.
When you're at the bench there and you're ruling on this sort of thing, you talk to them?
Absolutely. Most of the time is spent talking to them. I have had maybe 30 contested hearings in 10 years. We started with 34 people 10 years ago, and now there are 2,200 in the program here out of 8,000 on probation on the island. And it's expanded to 22 states in over 230 different jurisdictions. And it's because all these states have the same problem with people on probation failing and going to prison. And so the other indication about it working, I think, is we never get requests to change probation officers anymore, because they think they're being treated fairly. Before, the mean probation officer, as they saw it, would say, I want away from that PO. She's too tough. And now we don't get those requests anymore.
Yeah, you're more likely to listen to a parent who you think is fair.
That is the whole point of this. And procedural justice is discussed in law schools. I think many times in the system as it plays out, the defendants don't think the system is that fair. Things are delayed, uncertain, and then maybe really harsh when something happens. Here it's swift, certain, proportionate. The Chief Justice Moon supported this at the start. Chief Justice Recktenwald has been a vocal supporter. It's statewide in probationers. And it truly is. The defendants think they're being treated fairly. And I'm convinced that's why this is working.
HOPE is the acronym. What does that extend to?
Well, I had a contest among the probation officers and court staff to name the program. I had a number of entries. One of the early ones was Yank and Spank. That was the head of the sex crimes unit. But somebody suggested Hawaii's opportunity probation with enforcement. HOPE, it makes sense, it's upbeat, it's positive. The Justice Department now is sponsoring, it's a part of the federal budget every year. There's 7 new sites this year. They're visiting town this week. One includes the Lummi tribe in Washington State, Alaska probation and parole, Alabama parole, New York parole, Ohio.
So you're comparing notes. They learn from us. We learn from them.
Right. Well, we started this program here.
Okay.
And so it's being expanded. Now they're going to have to adjust it to their individual circumstances. But the idea, I cannot believe nobody did this before we did it. It's amazed me over the years. And as a matter of fact, somebody in Texas started it around the same time, but he must not have the same entrepreneurial spirit because it stayed small there. But we have good support throughout the system, and it's trying to make the system work better. And in this program, the people are, you're preventing victimization and crime, you're helping offenders and their families by avoiding the years-long prison sentences. And our statistics show that people in this program test positive for drugs 72% less often than probation as usual. And they're going to stay in prison for years half as often. So if you can prevent victimization, help the offenders and their families, and save the taxpayers millions of dollars in prison costs.
What's not to like?
What's not to like?
Yeah. One of the other things that was mentioned in Judge Recktenwald's speech was giving judges more discretion in sentencing and requiring prisoners to pay increased restitution. I don't think the public hears that much about it. How does that work, and how can you expand those things?
Well, through the Justice Reinvestment Initiative, which was supported by the Chief Justice, and it's now in about half the states. The idea is you bring in some folks from out of state, these experts from the Council of State Governments, so the Pew Foundation, and they look at your records. They look at public safety's records, and they discover who is in prison, what is sending them to prison, what are the drivers for that. And so based on that, legislation was passed, things were put in place. For example, in Hawaii, before that legislation, if you were on probation for a drug possession offense, a small amount of methamphetamine, cocaine, whatever, and you got arrested with another small amount of drugs, judges had no discretion. We had to send them to prison.
That's like the federal sentencing guidelines.
Right.
No discretion.
No discretion. And so the legislature had already, over the years, given us discretion. If somebody was on probation for a property offense and they picked up a small drug offense, we could avoid prison and leave them on probation. Or the reverse, small drug to property. The other two versions of that, property to property, drug to drug, we still had to send them to prison. Property to property doesn't bother me, because if they're burglarizing your house and they commit a new burglary, they should go to prison. But the folks, small drug to small drug, now we have the discretion to put them on probation. And now that we have hope, we can put them in there. So Hawaii Paroling Authority records show the number of people every year since the law passed keeps getting reduced. And our Justice Reinvestment Initiative is really a leader for the country for victims' rights. Because victims want to get restitution. You know, they want the person to pay back for the car they ripped off, or the house they damaged. Well, before this legislation, 10% of an inmate's wages would go toward restitution. Now, they make 25 cents an hour, so it takes a while to pay stuff back. Through the legislation now, it's 25% of anything in their inmate account. So the family puts in $100, 25 of that will go, and it's automatically now toward the victims. So justice reinvestment is a process. Texas was one of the first. Let's be smart on crime, not just tough on crime. And we do this the right way, and with the adults, it all worked out well, and I think because of all that, they looked at the juveniles to do this a similar thing. It's always going to be different in juvenile court and in family court than in adult court, but with the success of justice reinvestment for the adults, they looked at our state otherwise.
So on the restitution, the judge sets the dollar amount.
Right.
And it's not necessarily like in a civil court. It's with regard to both sides of the equation, so to speak.
Well, actually, the amount of restitution, it is identified in the pre-sentence report. They really look at this. If there's a disagreement, we'll have a hearing. Otherwise, now by statute, we have to order it, which is fine. Now, the amount per month that the person is actually ordered to pay, that's something that you may have a hearing on. Right now, if we send people to prison, it may be more appropriate to say 10% of their wages.
Yeah.
You know, then when they get out, they're going to have to, you know, work on it as well. It may be a freestanding order. But restitution is hugely important to victims. And one of the things we're trying to do both in Hope and Drug Court is let's get more people employed. If they're employed, they can pay restitution. And if people, you sit on them that way, they will get employed.
It's almost like building a civil tort into the criminal system, so you leave an impression on both sides. Yeah. When you announce these sentences, do you talk to the defendant? Do you explain to him, you know, that what you're trying to do by these sanctions?
Well, actually, and in Hope, the actual first hearing is called the warning hearing, and it's to encourage them to succeed. Everybody in this courtroom wants you to succeed. But because you're not in prison and you're on probation, whether you realize or not, you were making a deal with me and the probation officer, you're going to follow the rules. And from now on, if you violate the rules, you're going to go to jail. But the way you handle it, we're all human beings, we can make mistakes. The way you handle it, if you're not responsible, the jail time is going to be very short. And in fact, if you can go 2 years without a violation, this doesn't apply to sex offenders because treatment takes too long, but everybody else, you can go 2 years without a violation, I'll terminate your probation. And you can see it in their eyes, okay, 2 years is something I can actually get my head around. And every week we had 5 motions for early termination yesterday, we had 2 today. They come in, they haven't violated a couple of years. I tell them, good for you, we all clap. They paid their restitution, they've testing clean, they paid their court fees, and they're citizens. Dr. Hawken from Pepperdine did research on this, and in the last year, when she did the research last year, 100 people in the last 2 years had been let on an early termination. Not a single one had been arrested for a single new crime. It's botchy to talk about it, but we got to talk about stats.
That's Judge Steven Alm. He's in the criminal division of the First Circuit. And we also have Judge Mark Browning, we'll talk to next. He's in the family court of the First Circuit. And on my left, Justice Mark Recktenwald. He's the Chief Justice of the Hawaii Supreme Court. I hope you'll let us have these judges back again some other time to elucidate on
We're
some.
very, very excited to be here today, and they're doing amazing work, so I'm glad we're having this chance to talk about it.
Great to learn about this. We're going to take a short break. We'll be right back.
Aloha, welcome to ThinkTech Hawaii. My name is Josh Green. I'm the host of a program called Healthcare in Hawaii. I'm a physician. I work in the emergency department on the Big Island. I also serve in the state senate, which, please don't hold that against me, doesn't detract from my television program. We speak about all the big healthcare issues in the state. We get together on Tuesdays from 2 o'clock till 3 o'clock in the afternoon, and we try to talk about the most important issues in healthcare. This is a terrific venue for people to learn about healthcare. There are many programs on this station. We broadcast it later, not just on the internet, but also on OC16. Thanks for joining us. Please be informed healthcare consumers.
Okay, we're back. We're live with Justice Mark Recktenwald, the Chief Justice of the Hawaii Supreme Court. And we just heard from Judge Steven Alm of the Criminal Division of the First Circuit Court. He's the creator of the HOPE Project, which is going around the country. And we have Judge Mark Browning now. He's with the Family Court of the First Circuit. And he's been involved in a number of the initiatives that change our society, may I say that, change our judiciary, and by extension, our society right here at this table. So Judge Browning, what have you been doing in the family court?
I think you actually said it very, very well, and that is that family court is essentially the epicenter where all the important issues related to our children, our families, and our community come to a crisis. And in that regard, what we have tried to do, as the Chief Justice has discussed, is come up with a lot of various different and innovative ways of trying to resolve and solve problems. In fact, one of the points in terms of our vision statement is to be a place of healing. One of the areas that we've concentrated a lot of our effort in terms of focus this past, well, the last 2 or 3 years has been the area of juvenile justice. In order to be able to give you an understanding and the viewers an understanding of the impact of that reform, I need to explain to you a little bit of the background. Currently, and it's been this way for a number of years, over 5,000 kids are arrested and brought to our court every single year. Statewide, it's approximately 7,000 to 8,000. And it's really difficult for a kid not just to be arrested, but to be brought to family court, charged, and be presented in front of a judge. 80% of our kids who come to family court, whatever the charge may be, we end up finding out have substance abuse issues that are quite serious. And those substances include everything from ice, marijuana, alcohol, heroin, cocaine, drug, Oxycontin. We were talking about that earlier, Judge Alm and myself. Just everything you can imagine. I even had a young man who at one point would go down to his father's truck and siphon the gas out of the truck and bring it upstairs so he could get high off the gasoline. And you know, one of the sad parts about all this is, in particular with respect to that issue, is that as a community, we really haven't addressed this issue. It hasn't been a priority. And that is reflected by the fact that we only have really one substance abuse residential treatment center for kids throughout this whole state. Mental health is another issue. 60 to 70% of our kids have various degrees of severity in terms of mental health. There is really no mental health system for our kids, and that's why in the cases of some of these kids who situations are very, very serious, they're being sent to the mainland. there are over 20 kids who are in institutions on the mainland, which is absolutely not right. And what we found is that, say, 7 years ago, what the solution that was being used was to put kids and incarcerate them in different institutions. So, for example, at HYCF, the population at any given time was anywhere from 60 to 70 kids. Today, it's 20.
Great.
At DH, which is our holding facility, detention home, pretrial holding facility, which the Judiciary runs, the population 6 or 7 years ago, even maybe 5 years ago, was anywhere between 30 and 40 for the whole state. Today, there are 9 boys and 7 girls for the whole state in that facility. That's come about because we made a commitment that we need to do things differently. That investing in the front end, which is the right way to do it, wasn't being done. By the front end, what I mean is finding ways to help kids. Because it's real easy to sentence a child, a young man or young woman, to jail. It's much more difficult, but much more important and much more fruitful in terms of all the various different criteria to get that child help. And our message has been for years that these children belong to all of us as a community. So we as a community need to take ownership. And we as judges in family court have an obligation to speak to those issues, which we have. So in that regard, we have begun a number of different things. 6 or 7 years ago, we were selected by the Annie Casey Foundation to become a site for the Juvenile Detention Alternative Initiative. And that was a very important step because they provided us with the technical assistance, with the training, with site visits, with a variety of other different things for us to take ownership. And what we did is we created a community governing body to address these issues holistically. A year and a half ago, we were approached
Just
by
like the Access Commission?
Similar,
Okay.
similar, but it was much more responsive in that the focus was so broad. There were so many different things to do. For example, the issue of the disproportionate number of Hawaiian or part Hawaiian kids that are in the system, and issues relative to are we using our data correctly to decide how to help kids, and those kinds of issues. So what we found is that, well, we have all these great ideas, but we have to put something together to formulate, to push us into the next step. And the Pew Foundation came in, as Judge Alm mentioned, and they offered and gave us the opportunity, and the Chief Justice was tremendously supportive, and the governor, at that time, Governor Abercrombie became involved, as well as Senator Kim on behalf of the legislature, and I believe the Speaker as well. And they commissioned something called the Juvenile Justice Working Group, which I was co-chair. And in a matter of 3 months, we created legislation that was eventually passed that completely reformed everything that needed to be addressed in terms of standards, in terms of practices, in terms of a variety of different issues. One of the seminal points that was made, because we issued a report prior to the legislation, was simply one of the major things that was wrong with the system was the fact that judges and probation officers simply didn't have the tools. In other words, there weren't the services to help these kids, services to help these kids on the front end. And that in and of itself was going to reduce the cost for our community, our taxpayers. And it has. To incarcerate a kid at HYCF is approximately $190,000 a year, that much, as opposed to being able to give that kid the opportunity for us to intervene early on to get the kid, that child, the help, whatever that may be.
To say nothing of affecting his life and maybe making him, a long-term criminal because he was incarcerated.
That's exactly the point, and because that's what was happening. And so, family court judges in the juvenile system have 2 jobs, and one is the same as, say, the adult criminal division judges, and that is that sometimes we adjudicate, we decide if somebody's guilty or innocent. But the second part is much different. We don't just sentence. Our primary and most important job is to determine and figure out how we're going to help that kid, how we're going to heal that family. And so in that regard, there are a number of different initiatives, and I'll describe it very briefly. And they include the fact that we developed the 0 to 3 program that the Chief Justice talked about. The 0 to 3 program is a very, very important program because one of the things we found in the CPS system is so many of the kids entering the Child Protective Services system are at their most vulnerable age, between the ages of 0 to 3. And what was happening before is that these kids were being placed in foster homes, and the mother or father of these children weren't being given the opportunity to have that connection, have that attachment. And we know that that period of time from 0 to 3 is so critical in terms of brain development and being able to establish those attachments. So that is a very therapeutic court that allows us to help those parents be the people that they need to be, want to be for those children, and protect them at the same time. They include services in terms of all kinds of different parenting educations. It's a very intensive court. Another court is girls' court. Girls' court is something we developed. We were the first state to do that. Judge Karen Radius was the founder of that court, and we developed it because we found, and this was about 6 years or 7 years ago, we did a study. We commissioned Professor Chesney Lynn to do a study because what we were seeing that there were a lot of girls in our system, and they weren't violent. They were kids who had suffered tremendous amount of trauma. And so we had her take a look at it. We found that the juvenile arrest for girls was well above the national average for girls across the nation. And one of the problems we had is that our services were directed mainly at boys. So we needed something special that was directed towards uniquely addressing kids, girls in the system. And so as a result of that, we know how successful that program has been because the data we collect shows that at least over 80% of these girls that go through the court don't recommit or commit other law violations. Over 80% of them don't run away again, which most of them are run away 5 or 6 different times. And most of them, over 90% of them, don't commit other status offenses. So it's been tremendously successful. Wraparound services has been very important. We have some kids that are very challenged, and we need to get families engaged, and we need to get systems engaged to provide wraparound services to help kids. That's an ongoing project. Chief Justice has been very, very progressive about understanding how we need to address the issue of rehabilitation in terms of addressing accountability. So as Judge Alm talked about, with juveniles, we need to address those things immediately. In particular, how do we teach the kids that when you do something, people are hurt? You may not understand, say, shoplifting, how that hurts anybody, but it does. And in the past, what we did when we talked about restitution and we talked about how we address community service, which is a part of the array of sentencing things that we could do, is a lot of times it was punitive in nature in the sense that kids were out there picking up trash and things like that. We developed a whole new program that develops, is culturally sensitive, that allows the kids to develop competency in a variety of different skills, both job-wise and personally, And I'm sorry.
I just want to say we're out of time, but I just want to, go to you, Justice, to close. And my reaction to this is actually an emotional reaction. I mean, this is so powerful what you're talking about. I mean, when I was just started practicing, I saw so many mean things happen, and this isn't mean. This is just the other side of that. This is sort of a social work way of looking at judicial activity. And it's marvelous, marvelous. It saves people in our community. It builds a better community. It is the best possible thing to happen. I'm so delighted to hear these stories. You must be proud.
I'm very, I'm very proud to be part of this organization. And what we do, people believe in passionately. Our judges do, our staff do. And amazing, we had 1,300 people who volunteered their time at the Judiciary last year. And that's because people see what we're doing. They know that we can make an impact, and they want to help. And I think that really just encapsulates what you just said, Jay, which is there's a realization that we can help solve some of these underlying problems just by convening people, by bringing attention to bear, by bringing people of goodwill who want to help together, and giving them a path to be able to help.
Caring about the community. You should give that speech every year.
I should.
That's Justice Mark Recktenwald, CJ, the Chief Justice of the Hawaii Supreme Court. Judge Mark Browning in the Family Court, Judge Steve Alm in the criminal, Steven Alm in the Criminal Division. Thank you so much, gentlemen.
Thank you very
It's
much.
been
It's been a
wonderful
pleasure.
to talk
Thank
to
you.
Thanks for having us here.
Aloha.
Aloha.